father-in-law, who is the father of the respondent, passed on yesterday night. My client is in the morning mood. She's in the process of organizing to go to our home in Meru to be part and parcel of the burial programs. Therefore, she's not competent faced with such a massive death blow to proceed with this matter. And I have very strong instructions from her to pass her sincere condolences to her husband, Linturi, and to the whole Igembe community for the loss of senior Linturi. It's unfortunate, but that is the position. I did talk to my learned colleague when I got that information and indicated to him that based with that sorrowful situation, my client and myself will not be ready to proceed with such a big calamity. So on our part, now we are seeking that we take other dates after the burial ceremony has been conducted. That's all.
But I think it would also be unfortunate for us to use death as a platform to make conclusive statements as to the issue that lies before you. Whether the petitioner is the daughter-in-law of Senior Linturi is a matter the court will determine when we get there. It is presumptuous at this stage. It's unfortunate to use a tragedy to make statements that appear to determine the very issue before the court. Same applies to the claim that the Honorable Linturi is the husband of this lady. But I spoke to my colleague, as he says, and I sought instructions on this matter on whether we should proceed or whether we shouldn't proceed. The reason I sought instructions, Your Honor, is it's never the council's case. Perhaps we forget on the bar. We only speak on behalf of our clients. We have no case, my colleague and I have no case before you. The instructions I received was that, unfortunate as this development might be, we should proceed for the reason. Number one, there are many fundamental aspects of the respondent's life which are held in abeyance for close to a year now because of the pendency of this matter. There are many important aspects of the respondent's life which have been held in abeyance and in limbo, pending the outcome or the determination of this case. To illustrate, yesterday, Your Honor, we were showing you several properties of the respondent which have been frozen for close to a year now, based on a marriage we claim doesn't exist, but we'll get there. That's just one of the reasons, because I sought to know from my client why they would say we proceed in these circumstances. Your Honor, those orders issued in the countless suits we were alluding to yesterday have literally made life impossible for the respondent, but he has no choice because ours is a country governed by the rule of law. And my instructions were that the petitioner cannot be heard to cry louder than the bereaved. My instructions were that throughout, ever since she obtained those orders I'm alluding to, the petitioner has latched at every straw possible to extend the life of this dispute so that, of course, she can continue enjoying orders she does not really deserve. And those are the circumstances under which I was instructed that this very unfortunate development notwithstanding, we should proceed. In any event, the High Court itself was alive to the hardship. When the High Court directed that this matter be heard and determined expeditiously, it was out of the appreciation that those interlocutory orders, and we're not blaming anyone, Your Honor, it's very easy to get an interlocutory order because the evidence has not yet been tested like we have now tested it. But we cannot lose sight of the hardship. I will, if Your Honor permits a request, you allow my colleague, Professor Jakoya, to also address you on this request. And lastly, there is an aspect of the instructions I was given which I'd rather you hear the respondent himself in his own words, why you would rather, hard as it may be, have this matter proceed rather than be delayed further. Professor Jakoya.
Thank you. That, the defendant respondent's biological father passed on yesterday night, and that the plaintiff is mourning and cannot therefore proceed with the hearing today. The defendant's counsel has opposed this application and has made submissions that the defendant, a respondent, is in court today and ready to proceed. That the plaintiff cannot be heard to cry louder than the bereaved. He also submitted that the respondent has been put to hardship as a result of the multiple suits filed by the petitioner, and that his property has since been frozen, and that the petitioner is enjoying orders granted in those matters. There was also a presentation that the deceased herein has been in shock since learning that of these proceedings, and that the respondent was ready to proceed despite the bereavement. I've carefully considered the application for adjournment hearing. This court has previously made and directed that the hearing of this matter be fixed consecutively, that is to say, on various dates that follow each other. This has been done so as to cover sufficient ground and expedite the finalization of this matter. Those consecutive dates are also meant to cushion parties against any eventuality that may arise or occur, which may then delay the hearing on this matter if it is listed for one day. The respondent, whose biological father has passed on, is in court today and ready to proceed. And our condolences to the family. But be as it may, and to properly manage the hearing and finalization of this matter, I will adjourn the hearing for today. For one reason, that in any event, the petitioner is not in court. However, and going forward, so that we manage this matter appropriately, I will direct that parties avail themselves in court as and when required, and can only seek the court's intervention in terms of them being absent, so that the matter then may not proceed there. This court does not wish to delve into the cause of the death of the respondent's loving father, or the roles that either of them played in the constructions, as is a matter that are still pending adjudication by this court. This court will also not comment about the roles that may be undertaken by parties here in the burial arrangements, because that is not an issue before this court for determination. So we'll take out this matter for today, but I realize that we had fixed it on several days. We expect that on the next hearing date, the petitioner must be here for re-examination. Just remind me, how many days did you fix?
The